So welcome to everyone. It's wonderful to see you. I'm very, very humbled and honored to be here at the third annual conference of the Center for Truth and Justice. Also very exciting to kick off our multiple session here, and I'm very happy to be kicking this off with you all. It also just so happens that the three representatives here on this stage are some of my oldest friends and those that I respect the absolute most in this entire country. So I'm particularly honored for each and every one of you to be here sharing this stage with you, and I'm so grateful for your time. The recent forced displacement of tens of thousands of ethnic Armenians from Nagorno-Karabakh is a stark reminder to us all of the complex and enduring legacies of conflict. The region has borne witness to profound human suffering, including allegations of war crimes, crimes against humanity, and ethnic cleansing. These events call for a robust, legal, and humanitarian response. In the aftermath of such conflicts, justice is often elusive, but it remains critical to establishing a lasting and durable peace. Today's panel will focus on the efforts to achieve a lasting and durable peace and seek justice right here in the Republic of Armenia. So we'll be hearing from those that are working towards peace and justice on behalf of victims from Nagorno-Karabakh, on behalf of prisoners of war that are from the Republic of Armenia as well as information regarding the migration in statistics, numbers, and the incredible Herculean efforts of the government of the Republic of Armenia to support and house all of the refugees from Nagorno-Karabakh. So I think it's most appropriate we're starting here, right here at home in the Republic of Armenia, with three people who will give us the Armenian perspective. And I will introduce them one by one, but first let's have a round of applause for our guests here today. So I will introduce our speakers as they speak, and in order we will have Yeghishe Kirakosyan, Siranush Sahakyan, and Armen Ghazaryan. But first, as Judge Abkaryan alluded to, we do want to play a video for you that features the voices of some of the victims, which includes a woman by the name of Goharine from Nagorno-Karabakh that was set to be here but is instead on her way to Washington, D.C., and we're all very proud of her, and we wish her the best of luck in her testimony there. So without further ado, as soon as you're able, please go ahead and play the video, and then we'll just continue with our discussion.
Անդրազեստով միջազգային կառույցների հասարակությանը հանդրության իրազեկելու հետիքներ պատրաստ եք
Թուշին կյամ այդ շայիկա թա հինչա ինում եսի կոչի եկած լոխոս էլ հյուրուստի վախում կյամա մեր կողքին տրաքում ըտեղ հյուրը բախտը պիրում ա վիրավորվում ա հյուրը չէ զոհվում ա ըտեղ զոհվում ա գյուղապետին տղան պոլնի ծանդել է համարյա զոհված երկու նվեր Միքայել խոխենք հենք կուճր շեն այնում 12 ընտանիքը կունում հենք զոհ այնում ուտե հենք զոհ մի հատ ուժեղ պայթուն լսվեց Ես խոհանոցում էի այդ պահին, ամուսինս երեխաները Տերևանեսի հետ հյուրասենյակում էին ու ամուսնուս գոռոցից գոռաց Սերգեյը ու այդ պահին
Ես գետնին ինքի արդեն ուժ հավաքեցի, հասա մինչև հյուրասենյակ, տեսա, որ մեծ տղաս մի կողմ անկած, փոքր տղաս մի կողմ, կարմիր խաչից են գալիս, որ ով ծանր վիրավոր է, իրան տեղափոխենք պիտի Երևան, այդ թվում մենք ենք լինում, ես ու փոքր տղաս, ու ամուսինս ասում է, որ մյուս տղայիս դիակն էլ պիտի տեղափոխենք, ու արդեն Կարմիր խաչը Ադրբեջանի հետ բանակցություններ է տանում, որ պետքա դիակը տեղափոխենք մեր հետ, ու Ադրբեջանը ասում է, որ եթե քաղաքացիական զոհ է, պետքա դագաղով տեղափոխենք, ու դագաղ չի ճարվում, ինքան տեղեր են գնացել, հարցրել են, դագաղել չէր ճարվում, ծանոթների միջոցով մի տեղից գտնում են, չափսերով մի քիչ փոքր, ու որոշում ենք, որ թեկուզ այդ փոքրով կարողանանք դուրս բերենք։
Բոլոր հիվանդանոցները և դիահերձարանները փնտրում էինք քույրիկիս, գայանային գտանք, բայց ոչ դիահերձարաններում, ոչ հիվանդանոցում, Ադրբեջանյան Տելեգրամ կանալում, տեսանյութում քույրս էր, որտեղ նրան սպանել էին, մերկացրել որպես կին, Ադրբեջանի զինվորները քայլում էին քրոջս կողքով, ոտքով խփում ու ադրբեջանական բառեր էին ասում, քրոջս դին խոշտանգել էին, վիզն էին կտրել խաչաձև, մատն էին կտրել ու սարսափել էր, որ մատը դրել էին բերանը, աչքն էին հանել, ականջն էին կտրել, ամբողջ մարմինը կտրտած էր ու այդ ժամանակ ադրբեջանական տարբեր կայքերում մենք ստիպված հետևում էինք, թե ինչ ընթացք է ունենում քրոջս դին, քանի որ նրանք տեղադրում էին նոր տեսանյութեր, որոնց վրա խոշտանգումները ավելանում էր։
Մեր ծնողներից երկու հայրեր, Ջիվանն ու Լևոնը եկան ինձ ասեցին Անահիտ, մի բան ասենք կդիմանաս, ասեցի ինչ, ասես դու գիտես, որ հայկից ընդամենը մեկ ոսկոր, այսինքն մի կմախք չի, ասեց չէ, ինչ ես խոսում, ընդամենը մեկ կոնքազդրի ոսկոր։
Հենց սկզբից ոտքով տարել են արդեն գրաված Ղարաբաղի տարածքներից, դուբինկեկով, ցեպերով, փեդերով, 6-7 հոգով, մենակ դու, հուր պատայի խփում էին։
Հետո ասեցին, որ յուրաքանչյուր իրանք չենթարկվելու դեպքում մեկ հոգու փոխարեն սպանվելու են 3-ը, տենց զենքերը լիսկավորեցին։
Այլ ելք չկար։ Մարդիկ թողնելով իրենց հարազատ օջախները բռնեցին գաղթյան վերջ թվացող ճանապարհը։ Ես վերջիններից եմ, ով դուրս եկավ Արցախից։ Ամենածանր ապրումները ունեցել եմ այդ օրերին, երբ աչքիդ առաջ կործանվում է ամբողջ հայրենիքդ, կործանվում է ամբողջ ազգդ։ Եվ դա միայն հայրենիքի կորուստ չէ, դա ամբողջ արցախայության, ինքնության, ազգի ինքնության, դիմագծի և արմատների կորուստ էր։
We will start with the remarks from Mr. Yeghishe Kirakosyan. If you'd like to stand at the podium, that would probably be easier, more comfortable. So, Mr. Yeghishe Kirakosyan is the Armenian legal expert specializing in international law and currently serving as the representative of the Republic of Armenia before the European Court of Human Rights and also before all international proceedings. Previously, he was the advisor to the Prime Minister of Armenia, chief legal counsel at the Initiatives for Development of Armenia Charity Foundation, and deputy minister of justice. He has also worked for Yeghishe Kirakosyan and Partners law firm and served as a lecturer at the American University of Armenia and Yerevan State University. Mr. Kirakosyan holds a Master of Science of Laws from Stanford University Law School, Master of Laws in International Legal Studies from Georgetown Law Center, and a PhD and Master of Laws from Yerevan State University. Welcome. Thank you so much, Yeghishe.
Thank you. Appreciate. Thank you for the kind words. Thank you for the invitation to speak on this panel. It's already a tradition, the conference, CFDJ conference, and I like this tradition every year. And I hope this tradition will persist, and we'll have more and more interesting discussions and deliberations. And I think those kind of discussions and fora are needed, very much needed, given the international legal proceedings and a number of international legal proceedings that Armenia is involved in, and given also the perspective that Armenia joined the International Criminal Court just this year. The statute entered into force for the Republic of Armenia on the 1st of February, ratified last year around this time, and this even emphasizes more the need for this kind of discussions and deliberations. And myself being an international lawyer and coming from more deep academia, I can see now the growing interest towards international law, international criminal law, because Gurgen was speaking about 2015, but I can go even further back when I started researching and started participating in discussions about the Rome Statute of the International Criminal Court. It was back in 2004 when Georgia just joined the court, and there were regional discussions organized in Tbilisi, and I was part of them, and there were discussions about prospect for Armenia to join, but we had already a fresh constitutional court decision back then, which was declaring the statute unconstitutional. So this, I'm just trying to give you a good perspective. Back then, very few handful of people were interested in international law, international criminal law. Now I see a full auditorium of young professionals who are coming to international law and towards international law. Irrespective of the high skepticism that has been persisted in the country and around the globe, and I'm sure that we'll speak about this kind of skeptical approach towards international courts, international law today. I have been facing that many times myself, and although I truly believe, I still believe that international law or enforcing international steps taken by the country to enforce international law and rights are crucial, especially for countries like Armenia. And you know that there are international ongoing legal proceedings, different international legal fora, which Armenia are part of, and mostly a number of them are initiated by Armenia. There are certain legal proceedings initiated by Azerbaijan. One of the key proceedings that Armenia has is pending before the International Court of Justice, and the convention based on which the proceedings are pending is the Convention on the Elimination of all forms of racial discrimination. This is an important convention. I'll come back to this convention. Why am I emphasizing the importance? Because I think it has a lot to do with peace. And of course, we have proceedings at the European Court of Human Rights. We have at least 4 interstate applications against Azerbaijan. There are pending 2 applications against Armenia, and Armenia joined the International Criminal Court, which also allows Armenia as a state party to make a state referral to the court. That's another tool that Armenia has gained so far, which is making it's kind of in a way as an international lawyer professional, I'm viewing this also kind of building up the country's sovereignty, because by starting international litigation, by adding up new tools to your arsenal, it increases your chances, it increases your representation on the international legal fora. Let's start thinking a little bit why those international legal proceedings are important. What makes them so important? And why there is such need to pursue them? And of course, you may have heard or should have heard about the peace process and the reconciliation between the two countries and peace between Azerbaijan and Armenia. And of course, there might be also discussions about the contradiction between the legal proceedings and the peace process. And at first sight, that might seem maybe they are contradicting or they are excluding one another. But my conviction, my very deep conviction, is that they're not. Vice versa. It's, you will never have a durable peace without pursuit of justice. That's my very own, and I think, the philosophy which is based on the experience that we had over the past years. We just heard the keynote speaker mentioning about the interest of justice and interest of peace. This is a very important remark that made by the honorable judge. And I think in many respects, interest of justice and interest of peace are coinciding, because you cannot, there is no way you can achieve a durable peace. Why? I'll try to explain in two or three arguments that I think are important to keep. First argument that is important: when international legal proceedings are happening and a country is bringing a claim to international legal proceeding, to international court, making it public, and bringing the claims substantiated by evidence collected in line with international legal standards, that makes the country's story truthworthy, like it makes it more understandable to the world. Because without that, especially in the case with Armenia, I think you'll get lost in the world against Azerbaijani propaganda, because Azerbaijani propaganda will building up the lies and false narratives, which creates the basis for their positioning. But international legal proceedings are a very interesting fora for having a leveling field. There's that equality that exists there. And you have the equal opportunity to present your case, and in a very profound manner, which creates, it's kind of you can view it as a communication channel with the world. That's important. That's one thing. So the second stage for this proceedings is kind of establishment of the truth, creating a facts pattern that is true to what happened in reality, how this fact pattern should be assessed and qualified from the point of international law. And this is a very important exercise, because if you don't do that exercise, if you say if you don't do that exercise and you somewhat terminate that exercise, it means that you're hiding some problems behind the carpet or under the carpet. And which means that inevitably down the road, in some time, that will come back in a worse way. That's my understanding. So the next argument, or the next maybe viewing angle, is that I don't think that we should see it's a false contradiction between the peace and justice, because what is international dispute? What is international court? International court is a civilized method of resolution of disputes between countries. And having a dispute with a neighboring country and having a legal dispute with a country with whom you have a really long-standing, going deep into the past conflict is normal. It's very rational. It's very normal. It doesn't mean anything, because you should have claims, and you should bring your claims. That's important. The third point that I wanted to make is the human aspect of it, because in the end of the day, the claims that countries bringing before international courts are about people and for the people. If you are making these claims for the people, and you have, and of course the legal proceedings that are pending before different international courts are about more than 100,000 people, even more. I don't think it's 100,000. I think it's a couple of million people, because when we speak about the Convention on Elimination of all forms of racial discrimination, this is all about every Armenian. Because the racial ethnic Armenian discrimination against ethnic Armenians is directed against every Armenian around the globe. So this is about every Armenian, and living in Armenia, outside Armenia, who lived in Artsakh, and this is, and that's why it's kind of the need for justice, or the need for reparation, the need for retribution is important also for the people, from the viewing point of people, and to have this opportunity for humans. And
if we could start to just wrap up a little bit.
What is it?
Can we wrap up?
We'll try. Yeah, we'll try. I think it's a lot to say. It's a lot. There's a lot to say, but I'll try to. I just wanted to throw this several messages at you, and I will be very happy to react maybe through questions, because the international legal proceedings are extensive, and I've been making a lot of thinking in the past several years about the significance of these proceedings, and I'm sure that one last maybe remark that's maybe important from this point of view of the significance of the legal proceedings is the reactions that we're getting from the respondent state, for example. And you might say, or some might say, that Azerbaijan doesn't care about the decisions, doesn't care about international legal proceedings and the courts, and they just carry on what they did, and they do whatever they did and today. But it's wrong, because I think one of the core arguments why it's wrong is the reactions and the messaging that we get from the high-level political leadership of Azerbaijan. And the dialogue and the ideas of terminating the legal proceedings first was voiced by Azerbaijan on a very high level by the president of Azerbaijan. And why would the president of Azerbaijan wish to terminate legal proceedings, which he doesn't care? It's a false step. Then he does care, and if it comes up from that high level of on a power, that means that the Azerbaijan does care about the legal proceedings. It means that the legal proceedings are having a very direct effect on Azerbaijan, and it means that these legal proceedings that have been initiated by Armenia are highly, highly important, and for having a very restraining effect and restraining impact down the road. This is the last remark. There's many more, but I have in mind. Maybe I'll try to elaborate on them through questions. Thank you all for your attention and time. Thanks.
Thank you so much for those remarks. We'll go ahead and move right forward to Ms. Siranush Sahakyan. Whenever you feel comfortable, go ahead and take the podium. Ms. Sahakyan has over 15 years of experience in human rights, judicial reform, and corruption prevention. Previously, she served as chair of Armenia's corruption prevention body and ad hoc judge at the European Court of Human Rights. As the founder and president of the NGO Protection of Rights Without Borders and Path of Law, Ms. Sahakyan has been a prominent advocate for human rights. Her expertise is also sought by international organizations as a consultant. Currently, she serves as the president of the IC Law Center in Armenia and a member of the Chamber of Advocates of Armenia. Ms. Sahakyan has successfully led complex human rights litigation cases, particularly those involving Armenian victims of war crimes during the 44-day war in the 2023 ethnic cleansing. Thank you very much, Ms. Sahakyan. And before she begins, I just want to mention, which I forgot to mention, we will have an opportunity for a few questions and answers after our speakers have concluded. The staff will be sending around note cards. Please jot your questions down on the note cards just to make it a little more efficient for us. And they will be sent up to the stage. We'll read them for you. So just think about your questions, and they're going around now with note cards. So thanks for that. And please go ahead, Siranush.
Thank you.
First of all, let me thank to the organizers for making this event happening in this year as well. And it's my honor to contribute to discussions on these very highly important topics. ECHR is a key aspect of our legal struggle for protecting human rights of Armenian victims. For many years, ECHR was the last hope for justice for Armenians. In relations between Armenia and Azerbaijan, violations stemmed from state sanctions policy, violence, discrimination, lack of fair trial, lack of effective remedies. So the only avenue for restoring justice was the European Court of Human Rights. This hope rised from mid of 2000s when both Armenia and Azerbaijan acceded to this new system of human rights protection. My colleagues and I started a litigation from this period. So litigating on strategic human rights cases is not a practice closely linked to 2020 war or afterward developments. And from this perspective, if state action is new as a mean of protecting human rights violation, then victim representation has a long story. And at this point, we do have a dozen judgments from the European Court of Human Rights which acknowledge violations, and majority of them also amount to war crimes. The victim's perspective in these proceedings is characterized by a desire for recognition, accountability, and redress for the wrongs they have endured. From this viewpoint, ECHR is a critical platform where human rights experiences are tested, they are validated, and also protected. However, significance of these proceedings goes beyond individual grievances. They influence political processes, and they can shape the international community's view on ongoing conflict and behavior of state involved. This is especially true about Armenia-Azerbaijan viewpoints, as in a context of conflict, both countries are blaming each other for human rights violations, and those accusations are heard in political arena. But when we are studying the judgments and precedents coming from independent courts which verify the state versions, then we create the real image. The image we do have is there are acknowledgement of gross human rights violations and endorsement by the court that those violations were motivated by discrimination, hatred on the ground of ethnicity of Armenians. Though not all judgments immediately led to justice, however, we think that they lay the groundwork for future accountability and contribute to historic record of violations. Over the years, a wide array of cases have been brought by us on behalf of victims. Those include rights of prisoners of war, and those claims relate to unlawful deprivation of liberty, ill treatment, torture, denial of fair trials. We have numerous cases involving physical and psychological abuses. forced disappearances, where families seek justice for individuals who were forcibly disappeared, often with no information about their whereabouts or fate. We have cases where civilians and prisoners of war were unlawfully killed, including executions without trial. And victims unjustly detained or convicted without due process on politically motivated grounds. Following the 2023 war, the focus of our complaints shifted, reflecting the changes of nature of violations. So our new victims raise issues about destruction of property, expropriations, refusal of access to property, destruction of cultural monument villages, which threatens their identity, raising also concerns about genocide and violations of rights to return. Those cases and judgments, they impact on political processes. Azerbaijan is mandated as a funding state to remedy the situation. So this would lead to significant changes in national laws, policies, also practices. But on the other hand, these judgments influence state behavior by setting standards for human rights protection, and repeated judgments, they can also lead to significant internal and external pressure to improve human rights record. We believe that Azerbaijan is not only motivated to avoid further legal judgments against the state, but also concerns with maintaining their reputation and international standing. So we do believe that there is a dynamic relationship between the processes which will lead before European Court and politics. So the only perspective is not seeking individual justice, but also playing a role in shaping political processes, driving legislative and policy changes, and influencing state behavior. So as more victims of 2023 war turn to ECHR, these decisions will likely have lasting impact, influencing not only legal precedents, but also the political dynamic of the region, which is affected by the war. Thank you.
Thank you. Thank you so much, Siranush. Just to mention, if you have written down a card, just pass it down the aisle to the volunteers in CFTJ polos, and they will, either side, yeah, there's volunteers standing on both sides, so just pass your cards down, and we will collect those for Q&A. We now move on to our last speaker, Mr. Armen Ghazaryan. Armen is the current head of the Migration and Citizenship Services in the Ministry of Internal Affairs of the Republic of Armenia. Previously, Armen served as political and economics section assistant to the Embassy of Poland in Armenia and was a journalist and correspondent for Armen Press Armenian News Agency. Armen holds a master's in European Studies and PhD in political science, both from Yerevan State University. Armen has conducted postdoctoral research on migration and security at the University of Freiburg in Switzerland. Armen is also a very impressive polyglot and is proficient in Armenian, English, Russian, French, Polish, and sarcasm. Armen, please go ahead.
Thank you very much. Well, starting from the last remark, being intimidated by so many lawyers, the first thing that you might note, I'm not a lawyer, so I'm not going to talk much about law. Rather, I will try to do three things. First is to describe the deportation and the mass displacement that has taken place from Nagorno-Karabakh, and try to describe it from the receiving side, from the side of the Republic of Armenia and what government has had to encounter in this process. Secondly, I'll try to concentrate inevitably on the legal status of the people of Nagorno-Karabakh, which is a big topic and a big issue for the people and for the government as well. And thirdly, I'll try to explain to you how the legal status correlates with the social programs that the Republic of Armenia is implementing now towards the people of Nagorno-Karabakh. So, first of all, about displacement. Unfortunately, the displacement that started in September 2023 was not the first that the Republic of Armenia has had to encounter during the period of its independence. In my short-lived career as the head of migration service, I have personally had to manage 3 displacement events in the course of 5 years. So this is a challenge that we should take into account. Obviously, the first waves of displacement we have received even before Armenia's independence as a Soviet republic. It started in 1988. It continued well until the end of the First Karabakh War, but basically the main period ended in 1992. And this country had to receive more than 300,000, about 360,000 refugees from Azerbaijan proper after the pogroms from the cities of Baku, Sumgait, what was back then Kirovabad, currently Ganja, and these were largely Armenian populated cities as well. Armenian population was a strong presence there, so all these people had to come in. And this was the first huge wave of displacement that this country had to accept without, please note this, without having any proper reception infrastructure, without having policies, basically without having state at some point. Second wave of displacement we had to encounter in 2020. And during the war of 2020, we have received here in Armenia more than 92,000 displaced people from Karabakh, some of whom decided to stay, notably from the adjacent territories of Nagorno-Karabakh and from Hadrut and Shushi, mainly the areas which were occupied by Azerbaijan during the second Nagorno-Karabakh war in 2020. The main difference between those displacements and what happened in 2023, I would say, was intensity. Because, you know, in these periods, in a long span of time, you had to receive many people, so you had, as a state apparatus, you had some time to, you know, move and to adjust your functioning and to receive those people. But the intensity in a period of basically 10 days, receiving more than 115,000 people, and this is a crucial thing, from a bottleneck. This Hakkari bridge, which was described, it was a bottleneck. There was just one road. And some understanding this was easier because, you know, you could easily identify the people at the Gornizor and at the places where you received people and later allocate them. But this intensity and the trauma was multiplied during this period in 2023. Then comes the legal issue. Some of residents of Nagorno-Karabakh claim that they are Armenian citizens because they had Armenian passports. Some are saying, no, we should be recognized as refugees, etc., etc. So this debate, this internal debate amongst the population of Nagorno-Karabakh is not settled, and it's clear. But the government of Armenia, as a receiving side, had to make a decision about the status of these people, about the legal status of these people. First is the crucial issue of citizenship. Clearly, by the law on citizenship that Armenia has adopted in 1995, residents of Nagorno-Karabakh were not citizens of Armenia. That's clear as day. Second argument is, why would you provide passports, the symbol of your citizenship and the identification, to the people that are not your citizens? You would provide these passports because no one would recognize the passport of Nagorno-Karabakh Republic as it was, obviously. So those people would be deprived much of the opportunity to travel and to exercise their rights, be those rights educational, I don't know, healthcare, etc., in foreign countries, and mainly they would be deprived of the right of free movement. So Armenia and Nagorno-Karabakh, as two legal entities, settled somehow this issue by Armenia providing its passports to the residents of Nagorno-Karabakh and not entitling them with its citizenship. You would say, but they are exercising most of the rights. Residents of Nagorno-Karabakh were not exercising two crucial rights. This was the right to vote, and second was not a right, it's a responsibility to serve in the army in the territory of the Republic of Armenia. So these 2 points are crucial. And the other thing is, often we hear from many international colleagues that this is unprecedented. This is not unprecedented. This happens very few times in the world in history, but this happens. A lot of these things happen in Middle East, next door. Ask many Palestinian refugees who are walking around with the passports, please note, not just travel documents, with the passports of Lebanon and Jordan. So this I think this was important for me to note. But this double perception amongst the population of Nagorno-Karabakh persists. So what we did, we, in my opinion, cut a very fine line there and adopted a decision on awarding temporary protection to the refugees from Nagorno-Karabakh. By that, we could acknowledge the displacement that happened, the deprivation that people of Nagorno-Karabakh had to face, and also to give those people legal status that is compatible with international norms and standards, and this has been duly acknowledged by international organizations, including United States High Commissioner for Refugees, Mr. Filippo Grandi, who has clearly noted that these people are refugees. And the final thing, on a very short note, about the difference between the legal and social status is, usually in your life, in our lives, our social benefits and our social statuses are tied to our legal status. So we enjoy some benefits from one country because we are the citizens of that particular country. We here had to distinguish the legal status and the social status, and to give the people of Nagorno-Karabakh social benefits, emergency housing support, just based on the fact of displacement, because there were citizens of Armenia who were displaced from Nagorno-Karabakh as well, foreign citizens, etc., but we took the basic note of the fact of displacement. Only the long-term housing project, which currently government has announced, has some ties to citizenship, and the rationale behind that is that the government is making long-term commitment in providing long-term housing for the people of Nagorno-Karabakh, and the demonstration of that long-term commitment to the Republic of Armenia would be its citizenship. So we open the path to citizenship to refugees from Nagorno-Karabakh. So these were the three things I wanted to concentrate on, and thank you very much for listening to this. Thank you.
Thank you so much, Armen. That provides such important context to us to understand the support that Nagorno-Karabakh refugees received, and also some of the numbers. It was very helpful. Thank you. I have a few questions here that were sent up from audience participation. So these were written by audience members, and I think I'll just go through a few of them very briefly, since we're a little bit short on time. But starting with Siranush, the European Court of Human Rights requires that it says all national legal measures, but I believe they're talking about the exhaustion of domestic remedies. Basically, that domestic remedies are exhausted before applying to the court. How does this apply to victims from Nagorno-Karabakh, and how have you dealt with this requirement in your cases?
Thank you. Yeah, it's an important one. Of course, there is a rule to exhaust all domestic remedies. However, we do have also exception. And we have arguments, evidence to prove that available remedies are not effective, adequate towards particular group of victims. In past cases, we successfully argued for lack of effective remedies in Azerbaijan while dealing with Armenian cases. So the court agreed with arguments, and based on this position developed, all Armenian victims are released from the obligation to exhaust domestic remedies in Azerbaijan. So without modification of existing relations, the court would not revisit its opinion. So at this point, victims directly go to European court. They refer to existing case law to justify release from this obligation. But of course, Azerbaijan puts efforts to justify that there is a change of circumstances, and given so-called normalization of processes, Azerbaijani remedies could also become effective for Armenian victims. This is not a legal reality yet, so we are using this benefit of being absolved from this obligation.
A little bit related to that, I'll stick on this subject for a moment, because I'd love to know how your cases in the European Court of Human Rights have dealt with the territoriality issue. And for the benefit of our audience, if you could give like a minute overview of the past decisions that set precedent, Shiragov and others, on the territoriality, and how those have shifted in the precedent in the last year or two. So what, in other words, what territory are we on? What are we talking about? Whose land is whose? And who has obligations under the European Convention on Human Rights?
From admissibility perspective, one of the issues to be dealt by the court is the jurisdiction, that the case is compatible with court's jurisdiction, also from the territoriality perspective. And the main principle is that each state exercises jurisdiction over its internationally recognized territory. However, the second principle, which is in application, is extraterritorial jurisdiction. So in the past cases, Azerbaijani victims litigated against Armenia concerning violations that occurred in Nagorno-Karabakh, and court confirmed that Armenia exercised extraterritorial jurisdiction. Of course, the standards in use by the ECHR and other international courts are different. So we have more lenient standards setting by European Court in order not to leave protection of human rights in a vacuum. So based on the applied principles, Armenia exercised extraterritorial jurisdiction and was responsible for violations that occurred in the territory of unrecognized state of Nagorno-Karabakh. However, situation has significantly changed since the 2020 war. There we had Russian peacekeeping, which has an implication on sovereignty over the territory. And after the 2023, the whole territory is controlled by Azerbaijan. So the standards are valid until the development of 2020 war, and the court should form a new approach based on change of factual circumstances on the ground.
So as we sit here today, what is the court's position on effective control of the region between 2020 and 2023?
We don't have decision yet. We don't have decision yet, but human rights cases also relate to jurisdictional issues. So in future judgments, we'll have the finding of a court on this particular issue. In many cases, jurisdiction is proven through the involvement of state agents. So jurisdiction of a territory is not as important because physical control test is successfully argued. But in all cases where we have a situation-based human rights violation, the court will be required to address at first this jurisdictional aspect.
Very good. Very interesting. It will set a lot of interesting precedents as well for territoriality and jurisdiction. Yeghishe, a question for you. So we have essentially two parallel mirroring cases in the International Court of Justice, Armenia versus Azerbaijan, Azerbaijan versus Armenia. You, as the state representative of Armenia, have successfully achieved several interim measures orders in the International Court of Justice, which have said some really significant and important things about what was happening and who may or may not be liable for violations of the CERD. The question from the audience, which I kind of think about all the time but try to ignore and move on, is what are we supposed to do when Azerbaijan ignores the decisions and orders of the International Court of Justice, and what can Armenia further do?
It's a classical question. I think this question is being asked over again, and I'm trying to answer every time more creatively. I'm trying to think every time I'm asked this question to add on a little bit new aspect to that, because it is a kind of an important question. It seems very superficial, but it is a deep question. What do we do? Like if you speak formally when a state is not complying with a decision of the court, you have certain procedures that you can start in the court. The court has some internal rules which allows the court to create certain judges committees which oversee the implementation of the provisional measure decisions. But the problem with that is that the court never publicized this matter. Like they don't say that whether they have set up a committee, because it's an internal matter for the court. It's the discretion of the court. So we have been pushing the court to go down that road, but we don't know. But we have an assumption that there should be such certain commission. Of course, in certain cases, in relating to Colombia, for example, the court has gone so far as to establish even fact-finding commissions to send to the respective area to collect evidence, to see what's happening, how the states are behaving, whether they're complying. But it didn't happen in our case. Might be the case that in reality the court's decisions in this kind of issues maybe somewhat depend on the environment and the politics of the region, and overall I assume I don't want to make very far-reaching judgments. The second point maybe related to this question is there is also the debate about the Security Council, but the problem is that especially nowadays it leads nowhere, this kind of debate. Because given the geopolitical situation in the world, we understand that there is no chance that the Security Council will come up with a decision about the provisional measure decisions against Azerbaijan or in Armenian cases, given the disagreements between the permanent members of the Security Council, and to put it mildly, or to put it in a very diplomatic tone. And but in any case, even with that, there is some sort of debate now from legal point of view. The Charter speaks only about the Security Council role in implementing, executing the judgments of the court, not the decisions of the court. There is this kind of debate, but we know that there have been a practice of the court with regard to provisional measure decisions, very limited, but there has been. So this is the avenue. But what we do, if that's the general question, if they don't comply, we don't give up. That's the quick answer to that, because it doesn't mean anything. As I was trying to present in my speech, the layers of impact on the country are visible. You can see that it impacts the country's the behavior, like how they behave, what they say, how they act. And even more than that, when we were litigating in the International Court of Justice, in many instances, I can truly assure you that even during the hearings, if you have been following the hearings, you should see that Azerbaijani agents or Azerbaijani council members, they come up and make admissions in the court. Why do they make admissions in the court if they don't care about the court? That's another question, because there is a it's a really highly regarded body. You cannot, it's really, you cannot be dishonest before the court. You have really to be very respectful. That includes also the honesty and truthfulness, not be bringing false or not disagreeing with very straightforward facts. That happened during the last October's hearings regarding the forcible displacement of the Armenians. When we were requesting the court's number of provisional measures, the Azerbaijani agent and also the Azerbaijani council came up and started admitting a lot of things, including also the return, right, to return possibility. So my advice is not to give up, because it's a long process, because international courts are different. They're not like national courts. You'll have a decision, you have a compulsory service of execution of judgment or decisions, you go and then you execute it. You have to really be patient, and it pays off. I'm assuring you, you really have to be patient and wise, and to really work meticulously on every step. That's kind of a policy, and it's a sociology, it's social psychology, it's anthropology, it's politics, international relations, everything. Holistic.
Absolutely, very interesting. Yeghishe, just a quick follow-up question for you. Is it your position, or the team's position that's litigating in the ICJ, is it your position that it would be important for your ongoing proceedings to have the court comment on the legal status of the deportation itself? In other words, do you want the court to name forcible displacement? Ethnic cleansing is not a legal term of art, so it's not useful for us, except for in political terms it's used a lot. But forcible displacement is a legal term of art. There are others. Is that something that's useful to you in the ICJ proceedings, and is that something you're thinking about?
It's a good question. During the last hearings in April, when we were The court was hearing the case on the preliminary objections in the case Armenia against Azerbaijan, and also vice versa, Azerbaijan against Armenia. We had our own objections in the Azerbaijani case too, so it was back-to-back hearings, and we were arguing exactly that. And it's one of the core claims, actually, under the CERD. I mean, like the Convention on the Elimination of All Forms of Racial Discrimination exactly is designed also to protect this kind of things, because it's very much, it's a very good feed for this application, because but I understand also that ethnic cleansing is not a legal definition or legal or notion, but still lawyers do operate with that. We have been using in our presentations the term ethnic cleansing. It has been also we got reactions from Azerbaijan exactly on that. They're of course arguing the opposite. And they have been using, by the way, that in their case with relation to the events happening in the First War in the beginning of 90s. That's their argument, alas. So, but in any case, if we put it in legal terms, in mainly formalistic terms, of course we're arguing based on the enumerated rights under the CERD. That's Article 5, which enumerates certain rights which cannot be people cannot be deprived of those rights because of their ethnic origin. So one of them is being deprived of their home, so they are now of their property, and so they are in a homeland, and also being forcibly displaced, and which entails number of violations of the CERD. So yes, that's one of the cornerstones. And of course, the reparation for that, I mean, when you ask how you remedy that, of course, that's restitution. I mean, return. Restitution is number one. Return, of course, compensation will come up as a complementary form of reparation. And of course, satisfaction, which is the acknowledgement. So there's a combination of that. But this is the ultimate goal, but we are really further away. Now we're awaiting for the court's judgment on the preliminary objections soon. We hope that they will come up in a couple of months. So we're really looking forward to those judgments. And I hope by the end of the year, really hope. If you look at the website of the court under the pending cases heading, you see our two cases under deliberation section. So it says that the Armenian and the Azerbaijani cases are under deliberation, which means the court is now specifically working on the judgments. So this is overall the answer.
Great, thank you. Armen, I'd love to talk with you a little bit on elaborating on the status of the Nagorno-Karabakh refugees. So first and foremost, I just want to emphasize something that you said in your remarks, which is the people that moved from Nagorno-Karabakh into the Republic of Armenia have the status of refugee. Did I hear you correctly? It's also, you mentioned that the United States government has also reflected this position, that their status is refugee.
The status of refugee that we have sort of recognized, everybody has recognized that these people are refugees. I noted that UNHCR High Commissioner has made it clear that people who were displaced from Nagorno-Karabakh are refugees. Our legal conundrum basically was at the point, if those people are your citizens, how can they be refugees in your own country? Exactly. That's the basic conundrum, right? And we have made it clear that even though the population of Nagorno-Karabakh, residents of Nagorno-Karabakh, have been able to enjoy certain rights which are close to the rights of the citizens, they have never fully enjoyed the rights of the citizens of Armenia and have never been obliged to fully have all the obligations as citizens. And those two crucial elements have been voting and military service. So that allows us to recognize these people as refugees under Geneva Convention of 1951. Otherwise, the first article of the Geneva Convention has clause E, which says that if the people that have fled in a receiving country are fully enjoying the same rights as the citizens of that country, the convention does not apply to them. It would mean that we will not be able to bestow upon these people the refugee status and to say that, you know, they can have all the potential rights, in this case potential rights that Mr. Kirakosyan was elaborating, all the potential rights that the refugees might have under international law.
So you mentioned that there is now a proceeding. I don't know. First of all, when was the policy sort of developed that to invite citizens of Nagorno-Karabakh, refugees from Nagorno-Karabakh, to elect to take on full citizenship of Republic of Armenia?
You know, we have never had a moment where it was not there.
Okay.
You know, so since the moment that we have adopted the decision on temporary protection, it was October 27, 2023, and I think that this was a very crucial decision, at least in our migration type of legislation. You know, since that moment, the path to citizenship has always been open, and the crucial part for us there was the element of choice. So the people of Nagorno-Karabakh would have the choice whether they want to apply for citizenship or they won't. If they apply for citizenship, obviously, and receive it by the decree of the president, then they will have the full rights and responsibilities of the citizens. If not, they will continue to be under temporary protection. And the essence of temporary protection and the essence of refugee law is basically the idea of non-refoulement, which is not returning people to the place where their lives are in danger. And that was also so crucial to us, and in the discussions before adopting that decision with Mr. Kirakosyan and other colleagues, lawyers, we have been very much concentrated on the issue how to make it so that the principle of non-refoulement fully applies to these people. And temporary protection in our legislation, we somehow discovered that it is way more liberal than the European legislation. Actually, EU decision on temporary protection for the Ukrainians, for example, does not automatically recognize Ukrainians as refugees. It just grants them temporary protection for a certain period of time. Our law on refugees and asylum, our domestic law, simultaneously with temporary protection grants those people status of refugees.
I'm going to read a question from the audience, and you can answer it how you would like, Armen. Does accepting Armenian citizenship entail giving up citizenship to the Republic of Artsakh?
As the Republic of Armenia has never recognized the Republic of Nagorno-Karabakh, we don't know what that question is all about.
That's how I figured you would answer. So how do you square the Refugee Convention obligation to non-refoulement with the right to return? I think it's clear that, you know, everyone has their own choice. You emphasize this is a matter of individual choice, and if one chooses to continue their life in the Republic of Armenia, where they're safe, they are able to elect to have citizenship. Also, Yeghishe, you can answer as well. I would welcome you to answer. So my question to the whole stage, to anyone, is how do you square the desire of the right to return with the obligation of non-refoulement?
You don't. That's the simplest answer to that, because they are not something to be squared with. The clear, let's say, predisposition about the idea of non-refoulement is that you do not return people to the area where their life can be at risk And this is the crucial idea, where their life can be at risk, where they can be deprived of their lives, of the potential to exercise certain rights, right? So in that sense, we fully apply the idea of non-refoulement, and that has nothing to do with the second part, because as in one of the decisions that Mr. Kirakosyan has battled for in the ICJ, the court has noted that if there is a case of return, the return should be safe, unimpeded, and what was the third word? Expeditious.
In reality, when we are speaking about the right to return under the search conditions, it implies all these security and safeguards or requirements, because it means that the environment should be changed, at least from the one that people fled from. So that's the idea, because when we're speaking about the racial discrimination and the violations, when our claims are relating to the decades-long or systematic violations, so the Racial Discrimination Convention, which does mean that there is a huge environment of hatred against ethnic Armenians inside Azerbaijan, not only on a state level, but also among the population or a non-governmental organization, educational institutions. It's kind of widespread. So what does it mean, safe return? The safe return means at least trying to take steps to tone down this. That's and I understand that will take time too. And I hope that by the time when the cases are concluded, I mean the merit stage is concluded, this will start happening, because it's not a matter of months or weeks, it's a matter of even years. That's my understanding. Because it's, if Azerbaijan has been preparing itself on a hate propaganda over decades, it means that they have created an educated generation. I don't know, to erase that, it really requires a huge amount of work. I mean, first of all, that they will do that, but we don't see it yet. And at least steps that they are stopping doing that. I mean, like at least stopping propagation inside the country. That's important. So, so the right to return under the CERT entails the safe environment by itself. So it would not contradict with the non-refoulement principle. So in any case, that's kind of, they're complementing one another. Mm-hmm. Thank you.
If I add one more component. So within our court cases, again, we argue for the right to return. However, qualitative requirements also exist for the right to return, which implies safe and dignified return to their places. And so on the other hand, those returning should be able to exercise their identity, which means preservation of culture, monuments, and other important aspects to maintain their Armenian identity.
That's a very good point. Thank you. All the questions from the audience have been sent up, and about 4 or 5 of them include the G word. So I think I will just very simply ask it this way. Armenia is now a state party to the International Criminal Court. Among the Rome Statute is the crime of genocide codified in the Rome Statute. Does the Republic of Armenia have any policy, plan, strategy to have a referral to the International Criminal Court at this time? I'll just ask that way. Not so much for Armen. Sorry, Yeghishe, questions for you.
Okay. I'll take this one, Armen.
You can answer too, Armen.
I don't know.
If we answer generally, I mean, like the idea that Armenia joined the court at this juncture of what's happening, I mean, after the September event and even last year's ratification coincided exactly with the forcible displacement incident happening, as because the ratification was in early October last year, so it was exactly the same time, and then it entered into force on the 1st of February. So yeah, of course, the intention was there to at least to do the deterrence work for the future. But as per the state referral now, I cannot say anything. Even if there was a decision, maybe I wouldn't publicly announce it. Maybe it's not a good idea to announce that decision. In any case, was the question linked with the G word, or should I elaborate on that? Or G
a lot of
genocide?
questions came in from the audience, so I want to be respectful to the fact that there were more than about 4 questions from the audience that said, why are we not trying to prosecute the crime genocide?
If we're referring to the forcible displacement part, with all due respect, I really, as a lawyer, I don't think that we should really go down that path or not qualifying it on a genocide. That's my humble view, because my view is that it's better to, because there are crimes under the Rome Statute which are exactly what happened last year, like forcible displacement. That's crimes against humanity.
Crimes against humanity.
And persecution, forcible displacement, it's crimes against humanity, exactly as it was described in the Rome Statute. So it is falling under the subject matter jurisdiction of the court. That's one step. The second step is whether it falls under the territorial jurisdiction of the scope. That's the second question. Here we have this the Myanmar incident, the Myanmar precedent, let's say it in this way, where the court actually made this approach with regard to when the elements of the crime are committed on the territory of a state party to the Rome Statute. That makes it subject to territorial jurisdiction of that country, of those ICC too. So in this case, there can be made a good argument that the forcible displacement that happened last year is both subject matter jurisdiction of the court and also a territorial jurisdiction scope of the court, the ICC. So that's legal side of it. Of course, there is a lot of politics with regard to that. We know that the prosecutor is now very much engaged with Palestine, with Ukraine, which takes up a lot of time and resources of the court and the prosecution and the prosecutor's office. We understand that, and even if Armenia came up with the state referral, we understand that might take quite time and effort to focus the resources on that. But it doesn't mean that we shouldn't do that. I don't think that, but it's a very important tool for the security of the country. I mean, the ICC. It might seem it's not, but I think it is, because you may argue that the prosecutions at the ICC take long. For example, some may bring it examples of Ukraine, because the Ukraine recognized the jurisdiction of the court under Article 12.3 back in 2014, if I'm not mistaken. And then they did a second time a couple of years later, or a year later, and now they ratified it, finally. And after we did, by the way, which makes us even more proud, so we were the first one. So, it took really long time for the court to come closer, or not to go a bit deeper into the investigating, but I think it was more maybe politically motivated, but it doesn't mean that this doesn't have impact. Even I would say that the ICC, or triggering the ICC mechanism, might have even stronger impact on a neighboring country. Why? Because in the case of the ICC, when you are bringing a case, you are speaking about international criminal responsibility of an individual, specific individuals, not an abstract notion as state responsibility. You are specifically targeting people. That's why I think in that case, my humble opinion, that this has even more profound impact down the road. So it's a very important tool, and I think the considerations about using a triggering that should be always up in the agenda of the country. Thank you.
That's wonderful. Thank you. There will be a lot more discussions throughout this conference on Armenia's status as a state party to the ICC. For now, we will leave it there. And once again, I want to thank our illustrious speakers. And we will now break for lunch, and then we'll reconvene with the next session after lunch. So thank you.